Hello everyone, welcome to another episode of this particular video. By name, I am Japhet Okaka Ebosetali. So for today, we're under law of thoughts. Under law of thoughts, we are going to be looking at nuisance. Under law of thoughts, we'll be looking at the definition of nuisance. We'll be looking at the examples of nuisance. We'll be looking at taking a little view at public and private nuisance. I'll be looking at the purpose of the law of nuisance. I'll be looking at the distinction, the differences between public nuisance and private nuisance. So first of all, begin with the meaning of nuisance. Now, nuisance is any unreasonable interference. Nuisance is any unreasonable interference with another person in the use and enjoyment of land or a right attached to it. Nuisance is any unreasonable, so it must be unreasonable. It must connote, it must be unreasonable, it must be substantial, it must be material. Nuisance is any unreasonable interference with another person's rights. So, one of the most beautiful definition of nuisance is in the case of Waiter versus Surfing. Waiter versus Surfing by Client Bruce. This is one of the best definition of nuisance for me personally. Now let's look at the definition of nuisance given by Client Bruce in this particular case. He defined nuisance as any inconvenience, as an inconvenience materially interfering with the ordinary comfort, physical of human existence, not merely according to elegant or dirty modes and habits of living. He defined nuisance as an inconvenience. So nuisance is an inconvenience. For example, a neighbor is playing a loud music over there, it is interfering with you, it is disturbing you, it is annoying you, then that is an example of a nuisance. That is nuisance. So here he defined nuisance as an interference materially interfering with. So nuisance must be substantial. Nuisance must be material. It must not just be any little mode, any little dirty mode of or habit of living. That's what is stated. Any elegant or dirty modes of living. It must be something material. It must be a material inconvenience. It must not just be something so little, then you just approach the court. Mr. A is causing nuisance. It must be material enough. So now let's look at some examples of nuisance. One, a neighbor playing loud music. So by the time a neighbor is playing loud music, so loud, it's stopping you, it is interfering with you, it is annoying you, then that connotes nuisance. That is nuisance. Now the next example is blocking or obstructing a public highway. By the time someone uses vehicle or a lorry driver blocks or interferes with the use of public highway, then that is an example of nuisance. Another example is improperly parked vehicle. By the time a vehicle is improperly parked and then interferes with another person's right to access somewhere, to access a particular building, to access his house, to access his compound, then that is nuisance. So it must be material enough. So it's not as if you are walking on a road, and you just see an improperly parked vehicle somewhere. It's not interfering with anybody, it's not interfering with anybody's right to access somewhere, then you just take an action for nuisance. No, it must interfere, it must annoy, it must disturb, it must interfere with your rights. So that is an example. Now let's look at another example. Dust or fumes settling on and destroy crops. So if, for example, Mr. A is undertaking an activity, and because of his activity and because of the activity of Mr. A, there is dust rises and goes on to settle on Mr. B's vehicle, on Mr. B's house, on Mr. B crops. That is an example of nuisance. So let's then move on to the next. Disturbing another person with the enjoyment of his land by water, smell, smoke, fire, heat, noise, gas, vibration, and so on and so forth. For example, if Mr. A has a company and this company is is currently working, is currently going on, the activity of this company is currently going on, and because of this, the activity of this company, I'm in my house and my house is vibrating, my house is shaking, my house is vibrating, then that is nuisance. If Mr. A company is, because of the activity of Mr. A company, there is smoke and pacific smoke because of this company, then that is an example of nuisance. So we are done with the definition of nuisance, we are done with the example of nuisance. Now let's then look at the purpose of the law of nuisance. The purpose of the law of nuisance. What did the law of nuisance come to do? What did the law of nuisance come to do? The purpose of the law of nuisance. The reason for the law of nuisance. So the law of nuisance is based on the common law that you should so use your property as not to injure your neighbor. So that's one of the purpose of law of nuisance, is that yes, you have a right to use your property, but don't use it in a way that it will interfere or disturb your neighbor. Don't use it in a way that is going to annoy your neighbor. That is the purpose of law of nuisance. The law of nuisance simply comes to strike a balance. Yes, Mr. A, you have a right to use your property, but however, in the process of using your property, don't use it to the extent that it's going to interfere with Mr. B. So you get it. So the law of nuisance comes to strike a balance between these two. Mr. A has a right to use his property. Mr. B also has a right that is not going that Mr. A, in the use of his property, he will not be interfered with. So the law of nuisance comes to strike a balance between these two claims. Now let's look at one of the erudite statements made by Lord Wright in the case of Sedley Denfield versus O. Callaghan. Let's look at this particular statement made by Lord Wright. It says that a balance has to be maintained between the right of the occupier to do what he likes with his own and the right of his neighbor not to be interfered with. It says a balance has to be made between the right of the occupier to do what he likes with his own. It's my MP3. It is my MP3. It is my television. I can play music anyhow I like. Yes, you have that right. But the balance needs to be made within with you, the occupier, play your music, and your neighbor. That in the process of you play that music, you will not use that music to disturb or interfere or annoy your neighbor. So a balance has to be made with these two claims. Now let's continue with the statement of Lord Wright. It is impossible to give any precise or universal formula. So it simply says that there is no universal formula. There is no formula of this act done by Mr. A. Let's calculate it. Let's use like this. Is equals to nuisance. Any act done by any person that is this or that is that is equals to nuisance. There is no universal formula. There is no universal formula. But let's continue. But it may broadly be said that a useful test is perhaps what is reasonable according to the ordinary. What is reasonable according to the ordinary usage of mankind living in the society? What is reasonable according to the ordinary usage of mankind living in the society? So yes, there is no universal formula. Yes, there is no constant formula of you say that so and so act is nuisance. So and so operating a cassava machine is nuisance. There's no universal formula. But however, you need to consider the locality of the community. That's what Lord Wright is saying. You need to consider the environment, the community. You must consider an activity that may not be nuisance in the rural area may be a nuisance in the GRA, which is the government reserve area. An activity that may not be nuisance in villages. For example, having a cassava machine, you are grinding it and the noise is very loud. It's a village. People go there. Many people are used to it. So you have to consider the locality. But however, if you take that cassava machine to a GRA environment, if you take that cassava machine to a civilized city where there is no noise, it may not constitute nuisance. So yes, there is no universal formula, but you have to study the locality. You have to look at the people living in the community for you to know whether this act is nuisance or not. That is what blood right is saying. So the purpose of nuisance, as I will state now, is to strike a balance between the two claims, between the claim of the defendant to use his property as his like and the plaintiff not to be interfered with in the enjoyment of his land. So a balance needs to be struck between these two claims. So this is the purpose of the law of nuisance. Then we'll then go on to the types of nuisance. We'll then move on to the types and kinds of nuisance. So generally, there are two types of nuisance, which is public nuisance and private nuisance. There are two types of nuisance, public nuisance and private nuisance. So what is public nuisance? A public nuisance is any conduct that interfere with the reasonable comfort and convenience of the public. Is any conduct that interferes with the reasonable comfort and convenience of the public. So this particular conduct, it interferes with the public, it obstructs the public, it annoys the public. That's for public nuisance. But however, for private nuisance is any continuous and unreasonable interference with a person's use of his land. So you see, why public nuisance interferes with the public, private nuisance interferes with an individual right. Public nuisance interferes with the public, private nuisance interferes with an individual's rights. Now, let's look at the differences between public nuisance on one hand and private nuisance on the other hand. Now, first and foremost, which is one of the fundamental difference, is that public nuisance is a crime. Generally, public nuisance is a crime. This you can see in section 234 of the Criminal Code. You can see this in section 234 of the Criminal Code. Public nuisance is a crime except where a particular damage can be proved. Except where particular damage can be proved. Now, what is particular damage? What is particular damage? Public nuisance is a crime except where particular damage can be proved. Now, what is particular damage? That from the word particular, it means it's something peculiar. For example, there is a company in one locality, and this company is operating. Due to the activity of this company, there is loud noise in the community due to the activities of this company. This company is making noise due to the activities. There is noise and it's disturbing the public. Now, this is public nuisance and it is a crime. However, what if due to the activity of this company, Mr. A, who is residing in that locality, becomes deaf? Due to the noise of this company, Mr. A becomes deaf, but every other person are only interfered with just because of the noise. They only hear the noise of the community and it's disturbing them. But this Mr. A became deaf due to the activity of the company. Now that is particular damage. It is peculiar to Mr. A. While every other person is interfered with or disturbed by the noise, Mr. A became deaf due to the activities of this company. So in this particular instance, it will no longer be a crime. So generally, public nuisance is a crime unless where particular damage can be proved by a person. Unless where particular damage can be proved by a person. Particular damage. That's why I gave the example of Mr. A becoming deaf, while the rest members of the society are only disturbed by the noise, but Mr. A became deaf due to the activities of the company. So generally, public nuisance is a crime unless where particular damage can be proved. But however, private nuisance, on the other hand, is not a crime. It is not a crime. It is a civil wrong. Private nuisance is not a crime, but public nuisance is a crime. Now, let's then move on to the next distinction, which is in public nuisance, the conduct complained of is unlawful. In public nuisance, the conduct complained of is unlawful, while in private nuisance, the act complained of may be lawful. Now, what does this mean? Let me give an example. For example, obstructing public highway. This you can see in section 234 of the Criminal Code. By section 234 of the Criminal Code, paragraph A, it criminalizes obstruction of the public highway. So by the time Mr. A obstructs the public highway, that it is a crime and his act is unlawful. But for private nuisance, it is mostly lawful. It is mostly lawful. For public nuisance, the act is unlawful. For private nuisance, it is mostly lawful. For example, let's look at the case of Abiola versus Njoma. Abiola versus Njoma, where the defendant brought an action, where the plaintiff brought an action against the defendant due to the noise he was receiving from the poultry that the defendant had, due to the fact that the defendant had chicken, and this chicken were making loud noise in the morning, and he could not sleep. Due to the noise of this chicken, he could not sleep, he could not have sufficient rest. So he brought an action against the defendant, and the court granted the injunction. Now, if you look at this particular case, you will see that the act of the defendant was lawful. He had a chicken. It's not illegal to have a chicken. So in public nuisance, it is mostly unlawful. The act of the defendant is mostly unlawful. But in private nuisance, it is mostly lawful. It is legal. It is legal for the defendant to have private chicken. So this is another distinction between public nuisance and private nuisance. Now let's look at another distinction, which is an isolated or single conduct may be a public nuisance. You see, that's another distinction. For public nuisance, a single conduct, Mr. A obstructed the highway once, is a nuisance. He just obstructed the highway just once, but it's a nuisance. But for private nuisance, it has to be continuous. It has to be continuous. Why? Because if it's just a one-time activity, the courts might look at it as not material enough, not substantial enough. So for public nuisance, just a single conduct will connote nuisance. But for private nuisance, it has to be continuous. With it being continuous, the court will look at it, yes, due to the fact it's continuous, it is reasonable, it is material enough. But if it's just once, the court will say it is not material enough. So this is another distinction between private nuisance and public nuisance. Now, a conduct must affect several persons to be public nuisance. A private nuisance may affect only one person. Now, this is another distinction. For public nuisance, several persons needs to be affected. Several persons needs to be affected. But for private nuisance, it can just affect only one person. It can just affect only one person. For example, a company due to the activity of the company, there is noise. Now it affects several persons. That is public nuisance. But then look at the case of Ambiola versus Ijoma, whereby Mr. A, the defendant, had a poultry farm. Now, the noise of the chicken affected only the plaintiff. It affected only the plaintiff. The smell from the feces of the chicken affected only the plaintiff. So this is another distinction. For public nuisance, it must affect several persons. It is not necessary for it to affect everybody in public nuisance. Everybody must not be affected. You must get that clear. But however, it must affect several persons. The amount of persons affected must be substantial enough. It must affect a good number of persons. But for private nuisance, it can just affect only one person. So this is it for law of nuisance as an introduction into law of nuisance. Next, we'll be looking at public nuisance, and we'll also be looking at private nuisance. We'll be taking a deep view at public nuisance and private nuisance, and then we'll be looking at the remedies and defenses in a claim for public nuisance. As usual, I am Japhet Okaka Ibosetali. Thank you so much for watching.